So I wanted to offer some insights on the APA process here in the state of California. I think as listeners know, the APA stands for the Administrative Procedure Act. And California's APA, like those of the other 49 states, are patterned after the federal APA. And in each instance, they set forth basically the rules and procedures by which the executive branch agencies and departments are required to adopt regulations. The twin goals of the APA are to ensure, for purposes of that proposed rulemaking, that there's notice to the public, particularly the regulated community, and an opportunity for them to be heard. Now, in that vein, there are a few items of interest for those who regularly participate in the rulemaking activities of our state agencies. The defined purpose pursuant to the government code and the APA is to implement, interpret, and make specific. That's the purpose of a regulation, to make specific a statute. So if you're submitting comments on proposed regulations to a state agency, you really should describe how the proposed regulation accomplishes one or more of those stated purposes if you support the rulemaking. If, on the other hand, you oppose the rulemaking, then you're going to want to describe why the regulation does not accomplish them. In addition, California's APA, again found in the government code, provides 6 statutory standards. And these standards are the standards of review that the Office of Administrative Law, the OAL, is required to use when it's reviewing proposed regulations. The role of OAL is to ensure that a state agency abides by the APA when they adopt a regulation. So let's go through these 6 standards. The first is clarity, and clarity is one of the main reasons, according to OAL, that regulations get rejected. This is usually due to ambiguous or undefined terms that are used in the proposed regulation. So if the proposed regulation that you're commenting on is lacking in clarity, this may be your best avenue for success if you're trying to thwart the adoption of that proposed regulation. Next up is lack of necessity. Necessity is another common reason for OAL to reject a proposed regulation. So generally under this statutory standard of review, the Office of Administrative Law is looking at issues. Basically, has the regulatory agency distinguished between the what and the why? In other words, the why is often not done sufficiently by the adopting agency. So, in other words, OAL explains that the agency or the department sometimes doesn't provide an adequate showing of why the proposed regulation is necessary, instead spending most of its time in the explanation as to what is being done. OAL generally says that most state agencies do a pretty good job in explaining the what. In other words, what is the regulation proposed to do? But sometimes they are lacking on the why side, explaining well, articulating well why the regulation is necessary. And necessity is probably the easiest standard to comply with, even though that is the second most common reason for OAL rejecting a proposed regulation. I also think that folks have to appreciate the difference between the next 2 standards, which is authority and consistency. Often these 2 statutory standards are often confused by people who provide comments on regulations. In other words, a lot of folks who criticize an agency's proposed rulemaking will basically argue, hey, the agency doesn't have the authority to do this regulation. However, citing the authority standard is actually not the right one in that instance. The authority standard is pretty easy to adopt. It's whether the agency has general or specific authority, and this can be express or implied. And almost every state agency has explicit statutory authority to adopt regulations generally or specific regulations. Most of the big state agencies, the DMV, CARB, Health and Human Services, most of them have general rulemaking authority. And then, of course, there are instances where an agency is specifically granted authority, either permissively or mandatorily. For example, you might see, a specified department shall adopt regulations to implement this section, or a department may adopt regulations to implement this chapter. So oftentimes persons confuse the authority and standard with the consistency, because really, when you argue that the agency doesn't have authority, it's not that the agency doesn't have the statutory authority to adopt the regulation, because almost all of them do. Instead, you should be arguing that the underlying statute that the agency is trying to, remember, implement, interpret, or make specific is being improperly expanded or narrowed. In fact, you should be arguing that the proposed regulation lacks consistency with the underlying statute that it is attempting to implement, interpret, or make specific. So if you're commenting on proposed regulations, use the consistency standard and argue that the proposed regulation is inconsistent with the statute, rather than claiming that the agency lacks authority to adopt the regulation. As a final item, there continues to be confusion about whether separate comments can be submitted to the Office of Administrative Law after the conclusion of an agency rulemaking. The answer is no for regular rulemaking. The answer is yes, only instances of emergency rulemaking. Basically, for regular rulemaking, OAL doesn't have authority to consider submissions made outside of the rulemaking procedure itself. The statutes governing emergency rulemaking require the comments to be submitted directly to the Office of Administrative Law rather than to the adopting agency. Government Code Section 11349.1A says that in reviewing regulations, OAL must restrict its review to the regulation and the record of the rulemaking proceeding. So OAL is prohibited from considering any comments submitted to it directly for any non-emergency regulations. And the California Code of Regulations in Title I, Section 55A, specifically sets forth this prohibition on OAL being able to consider comments submitted directly to OAL by members of the public when the OAL is reviewing non-emergency regulatory filings or any certificates of compliance filings. OAL, again, only accepts comments on emergency rulemaking actions, assuming they're submitted during the specified comment period.